over to the councils.
Indeed, my lord.
All right. So it's a record of the proceedings in the
lower
court.
And this is handed up, my lord, in terms of section 235, which is also in the court bundle. That will be the confession pro forma for accused number 1 to Lieutenant Colonel Mboto on 30 May 2020. Mboto. We've taken out the statement itself.
Yeah.
It's natural, it's not admissible at this stage.
That's it, yeah. So, wait, it's Colonel Mboto on the 20th of what?
On the 30th
Sorry,
of
30th May
2020.
2020. Okay.
Then Exhibit GG will be the pro forma of pointings out by accused number 1 to Lieutenant Colonel Khadebe on 5 June 2020. It's also in the court bundle.
Right.
Then the state intends to use some of the photos, that is Exhibit GG Annexure 1, photos 1 up to 7 of the pointings out. And those photos were taken by Sergeant Mapakela on 5 June 2020.
It's Mapakela.
Yes, Mapakela.
Right.
Then Exhibit HH is a pro forma for a confession made by accused number 2 to Lieutenant Colonel Rapadu
Okay.
on 19 June 2020.
Okay.
Then Exhibit JJ will be a pro forma of a confession by accused number 2 made to Magistrate Gronier
Magistrate Gronier.
Yes.
Okay.
On the it's V. Gronier on the 24th of June 2020.
Okay.
We have deleted any parts that are inadmissible at this stage, and all those pro formas do not include the statements that have been made until the admissibility thereof has been determined.
Okay.
The state then calls, I haven't established from my colleagues, my lord, whether they are ready. We haven't had the chance to talk.
No, they told me they're ready. The CPD was the only one who was not ready on Thursday, is it? On Wednesday. But the other councillors all told me that they're ready.
As it pleases the court, my lord, before I even go to that, my concern is with respect to the exhibits that my learned colleague has just told the court about, which are for the purposes of a trial within a trial. We haven't consented or had any discussion with my learned colleague that same can be handed to court before we had discussed, because he says he has handed a exhibit, some of the parts are redacted. So we need to see the redacted parts before, so that we know we are.
The redacted parts, as I understand it, are in the said confession, alleged confession. It's not the or alleged statement. Is that not so?
Indeed, my lord.
Are you with me, Mr. Rapp? The redacted part relates to, according to the state, the actual notation in the alleged statement and the alleged confession and the alleged statements relating as opposed to the pointing out. So what, you say you never received those.
No, we have, my lord.
So what is the problem?
My objection was, I didn't hear that he says the redacted parts pertain only to the document. I don't know whether it's a statement or whatever. Let me say document.
Yeah, you're right, document.
That's the purpose.
And the photographs, you're saying that the ones which are taken by, for the pointing outs, they're taken by whom? Lieutenant Colonel?
No,
Rapp
they were taken by Sergeant
Sorry. Sergeant
Mapakela.
Mapakela, ne?
Yes, Mapakela.
And you say that those photos are 7.
Yes.
7.
Yes.
Have they been furnished to the defense?
Yes, they do have.
Mr. Do you have those photos
We do have.
of the pointing outs?
Yes.
Mr. Nisi, do you have the photos?
It's not only about the photos.
No. I'm asking the question. You will tell me whatever you want to tell me. Have you been furnished with the photos 1 to 7 of the pointing outs?
Yes, the black and white version of the photos.
Mr. Numalo?
Yes, I confirm that, my lord.
And
I
that's
confirm
fine.
that now.
Right. So what do you want to raise, Mr. Nisi?
We also requested the arrest statement, Madam.
The arrest?
Arrest statements from the from the state which we never received, and that is going to have a lot of a huge bearing on the trial, in the trial. But on top of that, Madam, on top of that,
Now let's do that first. Where are the arrest statements? They say there are arrest statements.
Well, they were furnished with the statement of Brigadier Gininda.
So the arrest statement in respect of accused number 1, number 2, number 3, number 4, number 5 were furnished to the councils.
Yes, as I've just indicated, Brigadier Gininda is the overall investigating officer. He's got a team who are assisting him, and I just want to establish from Advocate Nisi, whether he's referring to the statement of the main investigating officer or
No.
members.
As I understand him, he says he wants his client's statement relating to his client's arrest. Is that what you're not saying, sir?
that is so, Madam.
That's it.
Yes.
So it means the policeman, in whatever capacity you arrested his client, would normally make a statement.
Yes.
He wants that statement.
Yes. We can, as I say, I would imagine those issues are incorporated in the statement of Brigadier Gininda, but we can clarify that, my lord, off record with the defense.
What else, Mr. Misi, is outstanding according to you?
Number 2, Madam, with regard to the pro forma that my colleague has just referred to. I've been involved, fortunately, in a lot of stuff within the trials. On the questionnaire in that pro forma, there could be some instances where an accused person says something that should not actually be known by the court before the admissibility of that statement has been determined. It is therefore
No, it's not about it. No. It's about it's a statutory form, the pro forma. It's a statutory form. Your name, your address, your cell phone number, and then it advises you of the Section 35 rights, and then they categorize them. And then there are questions asked. Do you eat pap? When you say no, and the result is no, it's no.
Maybe the court does not understand.
I understand you well.
What I'm saying, my lord, is in those questions which would say, do you eat pap?
Yeah.
The accused might say something which for the purpose of a determination of the admissibility of that statement before it is admitted, that should not be made available to the court. In other words, that portion should then be deleted, or it should be concealed.
Mr. Balui, is that how you understand the law?
Yes, I understand where Advocate Miss is coming from. The only hint of what he's saying is contained in Exhibit HH. If I can ask the court to turn to Exhibit HH.
I don't want to see any exhibit at this stage.
Yes. There's a portion that we have deleted. I think I did say that when I introduced the exhibits. I said all the portions that are not admissible at this stage have been expunged.
Okay, so all the portions which are not admissible at this stage, you're saying they are expunged?
Yes.
Mr. Munisi, that's what he's saying. What are you saying?
The procedure, madam, is when he is doing that,
Yeah.
he needs to do that in conjunction with us. He cannot simply decide on his own to expunge those portions and then hand the statement to the court. And in any event, statements of this nature or an exhibit matter can only be handed to the court through the witness that is going to come and testify. It cannot be handed in advance. But more importantly is the statement and the parts that have been deleted. That should be done in conjunction with us so that we know what is it that should be deleted. Because we may think that this is not necessary for it to be deleted when we are of the view that it should actually be deleted. We cannot merely to decide to delete portions and then hand over the statement to the court. Thank you.
As a court, please, my lord, as far as the confession of accused number one is concerned, that issue doesn't arise. Those are the clients of Mr. Ramsipili. I suppose if there are any concerns, he would have raised that. But I can assure the court that, we tried with a fine-tooth comb to go through that. If there's anything that we've missed, my learned friends are at liberty to draw attention to that. But as far as the witness who is just about to come now is concerned, that issue doesn't arise at all. We can perhaps during the adjournment discuss that matter with the defense.
Do you have the Constitution? Because this court is obliged in a trial within a trial to use Section 35F of the Constitution. Do you have it? And if there is any evidence which is inadmissible, this court is matured enough to say that evidence won't be taken into consideration in the judgment of this matter because it is unlawfully acquired, or it is unlawful, or it is unfair. Who has a Constitution?
I've got a booklet, my lord, but I'm just trying to look for it now.
Yeah, let's read it so that So it's not about the state reducting this or that or that. It's about this court being enjoined by the Constitution which evidence to admit, whether it's in the interest of justice, whether it is against the administration of justice, etc. Let's read it. And this is the court which makes the decision which evidence will be taken into consideration. Yeah, we'll just read. Yeah, maybe we should just read Section 35, all of it. Although it is F, which is an issue. Section 35, arrest, detained and accused persons. 35.1, everyone who is arrested for allegedly committing an offense has the following rights. 1, to remain silent. 2, to be inform promptly, 1, of the right to remain silent, 2, of the consequences of not remaining silent. C, not to be compelled to make any confession or admission that could be used in evidence against that person. D, to be brought before a court as soon as possible, reasonably possible, that not later than 1, 48 hours after the arrest. 2, the end of the first court day after the expiry of 48 hours, if the 48 hours expires outside ordinary court hours or on a day which is not an ordinary court day. E, at the first court appearance after being arrested, to be charged or to be informed of the reason for the detention, to continue or to be released. F, to be released from detention if the interests of justice permit, subject to reasonable conditions. 35(2), everyone who is detained, including every sentenced prisoner, has the right, A, to be informed promptly of the reason for being detained, B, to choose and to consult with a legal practitioner, and to be informed of the right of his rights, of this right promptly. C, to have a legal practitioner assigned to the detained person by the state at the state expense if substantial injustice would otherwise result, and be informed of the right promptly to challenge the lawfulness and detention of the person before a court, and if the detention is unlawful, to be released. E, to conditions of detentions that are consistent with human dignity, including at least the exercise and the provision of state expenses, of adequate accommodation, nutrition, reading material, medical treatment. F, to communicate with and be visited by persons. 1, the spouse or partner. 2, next of kin. 3, chosen religious counselor. 4, chosen medical practitioner. 35(3), every accused person has the right to a fair trial, which includes the right, A, to be informed of the charge with sufficient detail to answer it. B, to have adequate time and facilities to prepare a defense. C, for a public trial before an ordinary court. D, to have the trial begin and conclude without unreasonable delay. E, to be present when being tried. F, to choose to be represented by a legal practitioner and to be informed of this right promptly. G, to have a legal practitioner assigned to the accused person by the state at the state expense if substantial injustice would otherwise result, and to be informed of that right promptly. H, to be presumed innocent, to remain silent and not to testify during the proceedings. I, to adduce and challenge evidence. J, not to be compelled to give self-incriminating evidence. K, to be tried in a language that the accused person understands, or that, if that is not practical or practicable, to have the proceedings interpreted in that language. F, not to be convicted for an act or omission that was not an offense under either the national or international law at the time it was committed or omitted. M, not to be tried for an offense in respect of which an act or omission for which that person has previously been either acquitted or convicted. N, to the benefit of the least severe of the prescribed punishment if the prescribed punishment or the offense has been changed between the time that the offense was committed and the time of the sentencing. O, the right of appeal or review by a higher court. You must be accorded that. 4, whenever this section requires information to be given to a person, that information must be given in a language that the person understands. 5, evidence contained in a manner that violates any right of the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. This is what enjoins me. So I can't sit here and admit unlawful, illegal, unconstitutional evidence. Section 35(5) says, evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render that trial or the trial unfair or otherwise be detrimental to the administration of justice. So if that form contains any evidence which is unlawful, unfair, illegal, unlawful, or it is acquired unlawfully, then this court can't admit it. That's what the law says. So, Mr. Baloi,
I can assure Advocate Nisi that if, and we can cut through to the chase on this matter, if there's anything he thinks should have been omitted, he can bring it to our attention. But we have taken every care to ensure that such utterances don't appear on the form.
no, but he says you must do it jointly with him and his colleagues. How you structure your case, in other words, you must discuss it with them. That's how I understand.
There's no such duty, my lord, that we must
Hello?
discuss. There's no such duty that we must discuss that with the state. They've been furnished with the copies, and as we've indicated, if there's anything that they think, and we will not place, my lord, anything that is admissible at this stage. We are aware of the issues that is raised. We've taken every care to ensure that such utterances don't appear on the pro forma, but if we've missed anything, it's more than at liberty, my lord, to draw our attention to it. But at this stage, my lord, as far as this witness is concerned, that we are just about to call, that issue doesn't arise at all.
No, but he says in respect of his client.
But he just said his client didn't make any statement.
Well, I don't know. That's the point. But he says if his client, if he hasn't made a statement, but if his client has answered in a manner which incriminates him, then he's got to be advised accordingly, so that should be reducted.
And it's not even, those statements are not yet before court, my lord. I think he's just referring to the pro formas that have just been handed up.
Yes, the statement. I won't see the statement
Yes.
until this court decides. What does Section 217 say?
Yes. Well, let's
quote it. Let's quote it so that people know what the law is about. 217. Let's read it. There are 3 requirements, as I recall.
Yes.
It must be made freely and voluntarily.
Without undue influence.
Yeah, let's read it. Let's read it.
Okay. Well, Section 217 states as follows, my lord. And it regulates confessions. Admissibility of confession by accused. Evidence of any confession made by any person in relation to the commission of any offense shall, if such confession is proved to have been freely and voluntarily made. So the first prerequisite is that the confession must be freely and voluntarily made, and that is the exercise, my lord, that we are now busy with. And secondly, it must be made voluntarily by such a person in his sound and sober senses. So the second prerequisite is that the person must be in their sound and sober senses. And thirdly, without having been unduly influenced thereto. So those are the three prerequisites, my lord, that we currently engage with, my lord, to determine the admissibility of the statement before the statement itself can be admissible.
Yes, fine, that's what the law says.
Yes.
And these courts can only make that finding after having heard all the arguments, all the evidence first, and all the arguments, and all the submissions by both the state and council. And Mr. Mnisi, you have the right at any stage in that pro forma form where you believe that your client, even though you say your client has not made a statement, where you believe that your client has given an answer which incriminates himself, or if according to your own knowledge and interpretation of the law, that answer will influence this court in finding in favor of the state. And this court can tell you, I only find in favor of the law. Not the state, not the defense. I am just a servant of the law. If the law allows it, I'm obliged to do it.
Yes.
If the law doesn't allow it, doesn't matter. I won't allow it. Okay?
That is appreciated, but this only does not, this does not only go to accused number 3. It goes to everybody.
All of them, yeah.
Yes. 1, 2, 3, 4,
5,
5.
yes.
The fact that I'm saying accused number 3 did not necessarily make a statement, that does not also go, I mean, that shouldn't go to accused number 1 and 2. The court has just indicated the exception of what the court just said.
No, Mr. Rappel also says his client made a statement. I don't know. He says his client made a statement. And his client was done this and that and that. And you are saying your client never made a statement. Mr. Ngomalo says his client never made a statement, and correspondingly, accused number 5, counsel says his client never made a statement.
What I'm saying, my lord,
Yeah.
is, irrespective of the fact that my client made a statement or not, the state says accused number 1 and 2, pointing out the confessions. That does not exclude me from participating.
No, it doesn't, of course.
Yes.
It doesn't.
That is the reason why then I'm saying, my lord, that any documents that pertains to them as well,
Yes.
it needs to be conversed with us before it can be handed over to the court. The court cannot hand documents to the court before those documents are conversed with us.
But you see
That
what?
is my concern.
Yeah, but you see what this gentleman is saying, Mr. Baloyi. He says you have that pro forma form. That's what he says. It's not me.
I don't have that pro forma form, which part of which has been deleted before it was handed over to the court.
Yes, Mr. Baloyi.
But we really need to save court time here. We've made it clear that as far as the first witness is concerned, that issue doesn't arise, and if Advocate Nisi can point us to a specific
Why don't you give
point-
Advocate Nisi the redacted part? You say you have redacted it.
Yes.
Just give him the document, which is you call the pro forma.
And it should not only be myself, but
No,
also-
please, Mr. I'm addressing your concerns. The other gentlemen can speak for themselves.
And
Mr. Ngumalo knows what to say.
that's exhibit HH, my lord, on page.
But give him the redacted part, your redacted part.
Yes.
That
Yes.
pro forma.
Yes. I just want
Because he says he doesn't have that one
Yes.
in his possession.
Yes.
Actually, what you should do, give it to each and every council. Rose, where's my register?
But yes,
Can you
but-
make copies of it? Before we start, can you make copies of that? Can you make copies of that?
Yes, I understand, but my suggestion, my lord, is that we draw, because they're still going to need this information. If they expunge it from their copies, they'll be without that information. If
No.
you
You give him what you have,
yes,
so that nobody must accuse this judge of conducting an unfair trial.
yes. Perhaps if it's acceptable to Advocate Nisi and to the court, we can draw his attention to the parts that have been expunged and we
I'm
can
going to
just-
adjourn. Draw, as you say, you're going to discuss it with him. But this court says you must make copies for that document which you intend using as pro formas,
Yes.
okay? Which you have redacted. All right, I'll give you 15 minutes.
All right.